4CRB 89.3 FM. Nice and easy on the Gold Coast.
A very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for today's Talkback, the law and you. This is your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All you need to do is get on that telephone straight away. 55208888 is the number. 55208888. Or if you're unable to get to the phone for any reason, you can always send us through a question on email at talkback@4crb.com. So that's talkback, all one word, at 4crb.com if for some reason you're not able to get onto the phone. We'll do our best to get to the emails if they come through, but obviously if we've got calls coming in online, then they will take precedence over anyone sending in a question by email. That number again, 55208888. Don't forget, if you're south of the Tweed River, to put 07 in front of the number. Otherwise, north of the Tweed River and right throughout Queensland, you'll get through straight away on 55208888. Thank you to all the people who called in last week. A great program last week. After a fairly slow start the week before, we had a wonderful number of calls and many and varied questions. So that was very interesting. One of the questions you may recall from last week came from Ivan, who was querying about one of his children, I think it might have been, had been divorced 6 months ago, and the query was when a property settlement application could be brought, and someone had suggested that you can take longer than 12 months to do it. And anyway, look, I double checked on that because my clear recollection was that the maximum period of time is 12 months from the date of divorce. There are rare exceptions in which the courts will grant an extension, but it has to be on very solid grounds. Basically, from the time you separate, once you've legally separated, you can bring that application for property settlement at any time until 12 months after your divorce. And of course, to get divorced, you need to be separated for 12 months first. So effectively, the total period of time would be 2 years from the date of separation. De facto relationships, of course, are different because people don't actually get divorced when they're in a de facto relationship. They simply separate, and therefore, under the law, if you separate from your de facto partner, you have 2 years from the date of separation within which to bring that application for property settlement. So whilst initially people may think, oh, well, why do de factos get a longer period of time? In reality, they don't. It's the same 2 years from separation. It's just that because there is no divorce, then there is no further 12 months. The other thing, of course, though, is that if you are married, you can be separated for years before you get around to divorcing. And so I suppose in those circumstances, couples who are married do get a bit of extra time as a result of that. So, Ivan, I hope that certainly clears that up for you. 55208888 is the number. Our telephone number again, 55208888. We presently have no calls online, so if you want to get through first and have the first question out of the blocks this morning, give us a call straight away, 55208888. We'll be back after this word from our sponsor.
Hi, this is Josh Mashman from Retirement Planning Partners. 4CRB listeners may remember me as the recent host of Finance Forum for many years. Today, investment markets are full of worried people who are losing their hard-earned money because of a lack of financial education. I'll be conducting a workshop with my colleague John Lomas to teach attendees how to create financial security and independence through sensible investing. Learn to recognise risks and how to avoid investment scams. Learn how to build a successful retirement portfolio so you maintain your standard of living you desire when you retire. Phone 5593 0005 to register for this free workshop, or visit our website rppartners.com.au.
Retirement Planning Partners is a corporate authorised representative of Madison Financial Group, AFSL number 246679.
Are you moving house, downsizing, or need more space? You Can Store It Self-Storage at Varsity Lakes can help. Call our sponsor on 5593-8355 and mention 4CRB for a 10% discount on new contracts.
You're in tune with 4CRB 89.3 FM. The Law and You is the program, 55208888 the number. And one thing that I would like to inform our listeners about, many of you may have read in the paper a week or so ago of the passing of Paul Gammon, a well-known Burleigh identity, councillor for Burleigh Heads for many years, and also a former board member of 4CRB. He passed away at the ripe old age of 90, so a great innings for Paul, and certainly our sympathy that of 4CRB is extended to his wife Judy and their family. We have some callers online, so we'll say good morning to our first caller, Lily. Good morning, Lily. How are you today?
Good, thank you.
How can we help you today?
I hope this is a very quick question. My mother made a will years ago, and she wants to change some things in it, and she doesn't want to upset the daughter, her other daughter, which I am also a daughter, because she's the power of attorney. And she wanted to make a new will, but she doesn't want to upset the other daughter who got the power of attorney. So, does she have to let her know that she wants to change the will? She wants to change the will.
No, the short answer to the question is no, Lily. A will is confidential, so the mere fact that someone might have been a beneficiary in a will, or you're going to change the provision that you're going to make for that beneficiary, even if that person was an executor under the will, there is no obligation to advise them of the change. It's different with the power of attorney, so if she was wanting to change the power of attorney to remove her other daughter as an attorney, then she certainly would need to notify her, particularly if that daughter has a copy of the power of attorney. But for the changes to the will, no, there's no need to do that. Bear in mind, however, that that her daughter or all children of a testator are entitled to see a copy not only of the first will that was made, but also previous wills if they call for them. All right then.
And so, will the new will tell the solicitor to hold it?
Well, your mother, as the person making the will, can ask her solicitor to hold the new will. Certainly, that would be the normal thing. And a new will would always have a revocation clause in it, which says that your mother is revoking the previous will. So obviously, as a result of that, the old will becomes revoked and therefore no longer effective. All right then.
And how if my mother dies, how will they know that there's a new will?
Because presumably the lawyer will know that your mother has made a will, you will know that your mother has made a new will, and so between them all someone will come forward to say that this is the will. So if she holds all of her wills in only one place, so if they're all held with her lawyer, including the revoked wills, then there can be no doubt about what the current will is.
That's
all
terrific.
right then, we'll have to leave it there, Lily. Thank you very much for the call.
Have a good day. Thank you.
Bye now. Time on 4CRB, 14 minutes past 9, past 10 south of the border, as we say a very good morning to Colin. G'day, Colin. How are you today?
Yes, I'm fine, thanks.
How can we help?
You?
Well, indeed. How can I help you today?
You're good. I had a commercial property which was basically surrendered to the mortgagee, which was one of the big banks. I subsequently received notice that I was not allowed to do anything. I was not allowed to enter, or I was not allowed to make any attempt to sell the property. I was basically totally hands off, which is okay. That's fine. Now, I've heard nothing since, and this was going back 3 or 4 months ago. Now, presumably they will take the steps to sell the property, and then they'll come chasing me for any shortfall.
If any.
What obligation do they have to keep me informed of that process?
They do have an obligation to keep you advised. The primary object or the primary responsibility of the mortgagee is to liquidate the property as soon as is reasonably possible and in a manner which will get the best price reasonably obtainable for the property. So it's in the bank's best interest, obviously, to sell the property up as soon as possible. The process normally is this, that they would take possession of the property, they would notify any tenants to pay the rent directly to the bank, they would get a valuation done of the property, and then they would work out from that valuation the best manner to market the property. And then proceed with a marketing campaign, and invariably mortgagee exercising power of sale will normally always sell by public auction, or in some instances they may sell by tender.
Right, okay. Yes, I pretty much understand the process. It's more their obligation to keep me informed that I was...
Well, I don't know that they have an obligation to be ringing you, but I think that you can certainly ring them and ask them what they're doing, to be kept advised of what is going on.
Yeah, because I have absolutely no control on it. They're going to come back to me for any
but they do though have legal obligations if they don't get the best price reasonably obtainable for the property. So, to that extent, depending on your financial position, it might be worth your while to even see if you could get a valuation done, so you have an idea of what the property is worth yourself, so that if they then proceed to sell it for a figure that's substantially lower, you've got some evidence. Or alternatively, look, it's probably better to get that done now. I was thinking you could do it after the event, but the problem is once it's sold, any new valuer is going to have the evidence of the sale, and that may influence their view. All right then?
Yeah. Okay, thanks very much, John.
Okay, Colin, all the very best. And the time on 4CRB is just past 17 minutes past 9. That's past 10 south of the border. The Law and You is the program. 55208888 is the number. That number again, 55208888. If you have a legal question or a query, as we say, a very good morning to Anna. Hi, Anna. How are you today?
I'm very well, thanks. I have just a quick question. My mother unfortunately passed away in November. According to the will, there are three of us are executors. 3 children are executors and 3 children are beneficiaries.
Mm-hmm.
My sister was living in the property in my mother's house. There was no agreement or anything. She was going off house sitting, coming back when she didn't have anywhere to live. So at the time of death, my sister was living at the property.
Mm-hmm.
However, we're just waiting for probate to be granted. But my sister is causing obstacles. She's not letting us into the house, my brother and myself into the house. And she's making demands that if we want to come into the house, we have to give her a week's notice. We're at the stage where my brother and I are wanting to go through and prepare the house for sale, which is in accordance to Mum's wishes.
Yep.
But can she legally not let us into that property, and can she legally give us these obstacles that, that we're not, she's scaring us, in a situation where we're saying that we're wanting to go and come into the house, we're wanting to go through Mum's things in order to organise things. She's scaring us that she's going to have me charged with being a dangerous person to be around. And suddenly she's decided that she's going to scare my brother and have him charged with sexual assault.
Oh, dear.
When she was a young kid at home. So, she's playing scare tactics with us, but unfortunately she's got a law firm that are sort of, she's going there and she's telling them, this is this and this and whatever, and the law firm's sending us letters and saying that, we do need to give her a week's notice before we come into the house.
Yep.
That we have no right to be in that house for days or weeks on end. Is that right or not?
Well, the situation is that she very well may be an occupant of the property, and unfortunately, as a result of that, the provisions of the Residential Tenancies Act would apply. What I would suggest... Even
if she's not paying rent or anything?
Yes, because sadly, I was shocked by this myself. And I mean, I've been practicing law for a long time, and this issue came up not so long ago in relation to a matter where I'm now the administrator of the estate, and one of the beneficiaries is living in the home and simply refusing to move out. And we've had to go through the process under the residential tenancy provisions to basically evict this person. They've even now that the notice is expired, they've refused to leave, and so we're now having to get a court order to get them out of the property. So what I would suggest you do is ring the Residential Tenancies Authority. Have you got a pen handy? I can give you their number.
Yeah, I have. Yes, I have.
Okay,
Yep.
so their number is 1300
1300?
Yeah, 366 311. Anna, this is in Queensland, is it, I assume?
No, sorry. No. This is in Tasmania.
Oh.
I do realise that law can differ.
Yeah, no, well, that's exactly right.
Yeah,
well, there's no point ringing the Residential Tenancies Authority in Queensland.
No.
Unfortunately, they're not going to help too much.
No.
What you need to do is look up online for the equivalent of the Residential Tenancies Authority in Tasmania, and then they'll more than likely have a 1300 number as well, so you can ring them.
Yep.
Or the other thing I was going to suggest was that you can also often look up they have information sheets in relation to your rights as a tenant, your rights as a landlord, etc. So you very well may be able to look up the equivalent of the Residential Tenancies Authority in Tasmania, and print out some of the information sheets they have there. And the problem you've got is that have you engaged a law firm to get probate of the will?
Yeah, there is.
And probably they're not prepared to advise you because they would say they've got a conflict of interest because they need to be instructed by all three executors.
Yes.
Yeah, so it's a rather unfortunate situation. But look, first stop, Anna, I would be looking on the web at the Residential Tenancies Authority or its equivalent in Tasmania. See what you can download from there to assist. And I would think they would have a 1300 number so you could give them a call and maybe talk it through with them and just see what you can do. But because of the fact that she's engaged a lawyer, I would certainly be recommending to you to make sure that you adhere with the legal requirements to get possession of the property.
It's all very complicated. I've never dealt with the law system at all, and it's just I find it extremely frustrating that we were always brought up to never engage in the law, and my parents never worked that hard for us to squabble
waste money on lawyers, that's for sure.
I'm amazed that the charges. I mean, I know that they go to uni and they that there's a responsibility there, but goodness me, I mean, $473 an hour. I struggle with that.
Well, you shouldn't be paying that though. Is that the lawyers who are acting for your sister?
Well, no, I haven't engaged in a lawyer. I mean, the only lawyers that we've got are the ones that Mum has the will and that are doing up the probate. My sister's gone off independently and gotten a law firm for her own, but I don't want to. I don't want to play around with that. I find that extremely frustrating, the fact that it just is so costly, and I really don't want to get involved in it. Yeah,
well, as I say, if you go to that website, take a look at that, look at what information sheets they've got, and give them a call and just talk it through with them and just see what options are available in Tasmania in the circumstances that confront you at the moment.
Yeah,
right,
that's excellent. Thank you very much.
Okay,
you put me in
Anna,
the right direction. Much appreciated.
All the very best with that. Bye now. And the time is just coming up to 24 minutes after 9. That's 24 minutes past 10 south of the border. 55208888 is the number. We probably have time for one more quick call if you have a question or a query and would like to get on that phone straight away. But while we do, my colleague Margaret Miller, who from time to time very kindly assists me in filling in on the Law and You when I'm not able to be here, is a volunteer at the Robina Community Legal Centre, and last Thursday had a query from a blind person about getting a guide dog or a seeing eye dog, and she'd been advised that it would cost her $10,000 to get a guide dog, and Margaret advised this person that I would give the answer in relation to this in the program today. And of course, Australian citizens who are legally blind can actually apply for a seeing eye dog or a guide dog through the Seeing Eye Dog or through Seeing Eye Dogs Australia. They have a website website, and you can go on that website to have a look at the process of getting a guide dog. It can be by referral or by contacting CEDA or Vision Australia through any of those. And Seeing Eye Dogs Australia are the only national provider of guide dogs in Australia, and have clients in all states. So that's the place to go. But the important thing for the lady, or the person, sorry, I don't know whether it was a lady or a man, who came into the Robina Community Legal Centre the other day, is that there is no payment required to get a Seeing Eye Dog as long as you satisfy the criteria. And so what I would recommend that she does is contact CEDA. They go through an assessment process to make sure that that it's going to be an effective use of a guide dog. They then have a training process, and basically the only costs that people are up for once they have a Seeing Eye Dog is that they have to pay probably about $35 a week, which is would be the cost of maintaining the dog with dog food and all those sorts of things. And they are required to take their Seeing Eye Dog to the vet every 6 months and provide CEDA with a report. But enough of that. We have one final caller, so we'll hope it's a quick call from Beverly. Good morning, Beverly. How are you today?
Good morning, John. Fine, thank you. How are you?
Very well. How can we help?
It's just a small query. My husband has set up a small share portfolio for both of us, and he's getting a little bit disturbed because he's heard that if he predeceases me, the shares automatically go to me because they're in joint names. Is that correct?
That is correct.
So what happens?
So if the shares are held in both of your names,
yes,
then yes, the shares will go to you on his demise.
Okay, and then does the taxation department have anything to do with that, or Centrelink?
Well, obviously those shares would then become your asset. So if those shares, obviously the income off those shares would have to be declared to Centrelink. There's no tax implications of you inheriting the shares or succeeding to the shares as the joint owner. So there won't be any tax to be paid, but the income off those shares will obviously need to be declared to Centrelink, and the value of those shares will have to be declared to Centrelink as well, so that if they, for example, pushed you over the limit for getting the old age pension, for example, well, that's obviously a bit of an issue. So they're things on which it's always very, very wise to take advice sooner rather than later. And probably the best thing for you to do, Beverly, would be to call back on Thursday at the same time when we have Finance Forum on. So you ring the same number, 55208888, and speak to the people who present Finance Forum, and I'm sure they'll be able to provide further advice to you in relation to the particular circumstances and question that you have.
Well, thank you for that, because if, it comes to amount of money, perhaps you might sell them first rather than wait till either or passes away. Well,
bear in mind that if you sell the shares and you make a profit on them, then that will be taxable.
Yeah.
Whereas if your husband passes away and the shares automatically pass to you, there is no tax.
There is no tax.
Yeah. So they're the things to bear in mind. But ring Finance Forum on Thursday, same number, same time, 9 o'clock the program starts, and I'm sure they'll be able to assist you with some advice.
Well, thank you very much.
Okay then, Beverly, all the very best.
Thank you, John. Bye-bye.
And the time on 4CRB is just coming up to 29 minutes past 9, and just finishing off on that response in relation to the question that Margaret Miller got concerning the Seeing Eye Dogs. I mentioned just a moment ago that there is an obligation to take the dog to the vet every 6 months and send that report into CEDA, but it was mentioned that many vets do in fact offer discounts for seeing or for examining Seeing Eye Dogs, but that's entirely between the client and the vet, so just bear that in mind. But if any major health problems occur, CEDA may consider providing assistance with vet bills, but that's assessed on a case-by-case basis. So contact Seeing Eye Dogs Australia. Their telephone number is on the web, or info@ceda.org.au. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning again for The Law and You. I'll look forward to being back with you next week for another program. Thanks to all our callers, but as always, until next week, it's goodbye and God bless.